My name is Christie Arkovich, and I'm a Tampa Bay attorney. We do a lot of student loan work. We do a lot of bankruptcy work, as well as foreclosure defense and some garnishment things and things like that. I wanted to briefly talk about how to keep your car in bankruptcy. With the high values of cars in the last couple of years, we have seen some more difficulties in bankruptcy for a client who wants to keep a vehicle. It may be that that vehicle is paid off to where they have substantial equity in the vehicle. It might be that they are substantially underwater in the vehicle, and they've continued to put negative equity from one trade-in to another, and eventually they have a car that might be worth, $10,000, but they actually owe 20 on it. And so some of the rules that apply in bankruptcy with vehicles are designed to perhaps reduce the amount that you owe on the vehicle. But you have to own the vehicle for quite some time, about 2.5 years, which is 910 days, and that's called a cram down. So if you are substantially underwater in a vehicle, you can actually cram down the lien, the amount that you owe on the vehicle, if you've owned it more than that 910 days or 2.5 years. So when we have a client come in that's close to that deadline, we want to delay a short time so that they can reach that deadline and we can cram that vehicle down. I have done a prior blog on the till interest rate. When interest rates were low, we often could reduce the amount of interest well below what the car loan required by contract. That still may be relevant. We do still see rates that are lower than contract rates often, usually for our poor creditor, our clients with the poorest credit scores. If you had, though, a loan of 3 and 4 and 5%, it's not likely that changing the interest rate using the till value with the increase in interest would really help you much. So that's really going to help those with the poorest credit with interest rates that are well above 10%, drop them down to something that's more reasonable. So we've got two methods. One is we cram down the value. Another is we kind of cram down the interest rate, essentially. Another thing you can do is you can let a car go in a bankruptcy. So you might purchase another vehicle. It may be before the bankruptcy, maybe after or during the bankruptcy, but essentially you want to continue to make payments on that vehicle who is dollar for dollar equal to the amount of equity you have in the car. So let's say before you file a bankruptcy, you've got two underwater cars. You want to let them go into bankruptcy because they're costing you, $500 or $700 each. You owe a lot more than what they're worth, and they're not really serving your needs. You can let them go into bankruptcy, and you can perhaps purchase a third vehicle that you intend to keep throughout and after the bankruptcy. We often will suggest that a client might want to consider doing that beforehand if they are eligible to do so, as opposed to do so during the bankruptcy. Again, they're making the payment. They're not purchasing a car right before bankruptcy to only file bankruptcy on it. They're making that payment. They're keeping that car. But that is a long-term solution for them. The car payment's reasonable, it's under warranty, it gets good gas mileage, it fits the family's needs. That's something that through good planning, you might want to do that before filing, and then get rid of the stuff that doesn't make any sense, the gas guzzler, the whatever it is. And then I did want to discuss before we go the cross-collateralization clause. A lot of people don't know what that is, the impact it can have, and who even has it. So if you have your car financed through a credit union, or at least we see a lot of it with credit unions, or some other entity that you also have other debt with, it might be another car loan, might be a credit card debt. Often in the agreements, you'll see a cross-collateralization clause, which means that if you don't make payments on a credit card, for instance, you basically are going to have to pay that credit card debt in order to keep the vehicle. They cross-collateralize the credit card debt to the vehicle loan. So let's say, for example, you walk into a bankruptcy, you owe $5,000 on a vehicle that's worth $5,000. And let's say you have $15,000 of credit card debt. Very, very common picture that we see. And so the credit union might assert that those debts are cross-collateralized, and you would have to pay the $15,000 in credit card debt just to keep your vehicle, even though otherwise you're equal to its value. You're paying it off regularly, and you're even current in it. So what you want to do is you want to make sure that you don't have a cross-collateralization clause that could affect you. What we suggest is that you make sure that your credit cards are through different agencies than your vehicle loans. That's the best thing. Also make sure that if you have multiple vehicle loans with one creditor, if you're going to give one up in bankruptcy, make sure you don't have that cross-collateralization clause that could impact the one that you want to keep. So when you have questions about what is this clause, do I even have this, reach out to us or some attorney on your behalf. They can look at that, tell you what the impact is. You need to know before you file. You don't want any surprises after you file a bankruptcy. We're very thorough in our consultations. And we don't see surprises in our bankruptcies as a result of being more thorough in a consultation. For instance, in our consultation, we spend time talking about what your financial circumstances are, what exactly would happen to you and with your debt and with your assets. We don't talk a lot about ourselves during the consultation. You can ask, and there's a ton of information online about us, but why spend the amount of time that you have with us talking about us? We want to talk about how your case is going to be impacted if you decide to file bankruptcy, what the timing is, and a number of other factors. So if you'd like to set up a consultation, the best way to reach us is 258-2808, or email us at info@ChristieArkovich.com. We are happy to do a consultation to discuss bankruptcy options with you. And keep in mind, if you do have student loan debt, now is an excellent time to perhaps file to discharge that student loan debt. It's something we've never been able to do before with federal student loans, and it's a ripe area that we anticipate being very active in. We've already started filing. We have a lot of private student loan discharges under our belt. We'd like to add a bunch of federal ones now that the law has changed. So good luck out there and stay safe, and hope you have a great 4th.